IVM.
Welcome to All Things Policy, a daily podcast supported by Pragati, a flagship media initiative of the Takshashila Institution. We're a bunch of policy nerds based in Bengaluru, and we like to bring a fresh perspective to Indian affairs and an Indian perspective to global affairs. So grab a cup of coffee, sit back, and join us for today's chat.
Hello and welcome to All Things Policy. My name is Rohan Seth and I am here today with Prateek, Waghre and Sapni Ji Krishna. One of the few things that I really love about recording this podcast is the amount of stuff I get to read. I mean, the government's coming up with new regulations around the clock. And it's really something to keep up with all of that. I mean, we've seen, I think this is the third document we're going to be talking about. It describes the legal landscape of tech policy in India. And I get to break that down with some of the finest minds in the business. So let's begin, Sapni. Can you put this document in context, this fascinating reading, and tell us more about it?
Thanks, Rohan. So as you said, this is the third document in our inquiries into the governance of digital communication networks. So as we've mentioned in previous episodes and as part of our inquiry, we've defined digital communication networks as composite entities, which basically have the capability to scale. Those are products, internet-based products or services that can enable instant communication to happen at scale, and that is helmed by operators or firms that have designed or operate these products, and that they are networks, and these are groups of individuals or entities that sort of adopt and use these services while interacting with each other. So this is broadly what we have defined as DCN, digital communication networks. So within that definition, in that broad definition, a lot of your social media, so-called broadly attributed as social media, including your Facebooks, your WhatsApps, your Twitter, YouTube, these are like currently siloed, categorized into different silos. So our definition of DCN sort of bring all of that together as mediums where digital communication happens. So this particular document here, I tried to look at the Indian legal landscape on online harms. So why this at the moment, as Rohan correctly pointed out, there is a sort of interest in revamping the entire legal system around digital communication networks in our terms and around social media and the internet in general in broader terms. So in that context, right? So where there is interest from in the public, in the legislators, so including your parliamentarians. I think recently there was the MOS of METI also gave a statement in a closed door discussion, I think with NASSCOM, where they mentioned that the IT Act is sort of not comprehensive enough, etc. So in that context, and in addition to that, there is this sort of momentum across the world. So right from Australia to UK to even, of course, in the US, there are, I think even Brazil for that matter, there are conversations happening where people want to sort of tackle the harms that happen on social media platforms, quote unquote that. So the idea behind this document is to see where we stand right now within the Indian legal landscape, as in what can we do to address online harms. And in that process, what we are trying to achieve in a larger way is to say that before we jump in and act on this impulse that the internet is a wild west and it's completely unregulated, etc., we sort of look at bringing in more nuance to it, saying that yes, there are problems, but we also have a bunch of solutions. We also have solutions that are currently in place, and the implementation can make a difference. So that is the motivation behind this, and it helped that there was an incredible paper in the TechReg journal based on the UK's approach on online harms, on the online safety harms sort of approach to regulation of technology platforms, more focused on internet. But for us, it has great impacts on regulation of social media. So this is the context where all of this stands.
And if I can just add one point there, something very quickly, it's also so you mentioned that the Minister of State had made a statement in a closed door meeting, in the last, also in before the current Parliament session went on break. Even the minister made a statement in the House talking about the need for stricter regulation of social media. Right? So it all sort of plays in to this current scenario, right? Wherein we're looking at new types of regulations, and like you said, I think it's important to get a sense of the current landscape and figure out what the existing laws are and how they apply.
Hey, that's quite fascinating. One thing, sort of, before we sort of get into the next question, is that this also reminds me of my time in New Delhi. So I was working as a tech policy analyst, and I remember this such discussion about what to be regulated, who should be regulating it. So, for example, we'll get public consultation from the Telecom Regulatory Authority of India on OTT platforms, and the first thing my employer would say was that, is TRAI really the right authority to regulate this? Should MeTV be doing this, and so on? So really, I think there's a history of sort of who regulates what, should it be regulated at all, and so on. And it's just a fascinating space to be in. That side tangent aside, let's talk about what's actually in the document. So Sapni, I'll come to you first.
Right. So within the document, we've tried to sort of firstly define what we are tackling as online harms. So what in this document specifically, what online harms means is that a set of actions that can occur on DCNs that can cause legal injuries to users, whether those users are individuals or group of individuals. So legal injuries in that sense, like it could be, there are injuries which there are in non-legal terms. There are effects on people which need not be necessarily considered legal injuries because a law does not criminalize it or penalize it, etc. So right now we've limited that scope to sort of look at exclusively on legal injuries. So within that scope, we have identified a range of harms. So that ranges from actions on as in calls on social media platforms like, say, Instagram, where self-harm is sort of, there is some sort of advocacy for self-harm, etc. So that can easily fall into the definitions of abetment of suicide as given in the Indian Penal Code. So ranging from that to child sexual abuse material, how to deal with that, and of course the very always in the limelight defamation laws, which is something we see too often in cases of social media related on activity or posts on DCNs. So that is what we are looking at. So we've identified instances like that, and on the basis of those instances, I categorized them as two. One, like broadly, these are two categories. So one is harms clearly identified as a legal injury by the law. So which, as I said, the example of abetment to suicide, or even for that matter, if you look at child sexual abuse and exploitation, there are a range of laws already in place. That includes the POCSO Act, that's the Protection of Children from Sexual Offences Act, the Information Technology Act, the IT Act, and obviously the Indian Penal Code. So we've sort of identified what are the provisions there and how you can go about it. And then again, a range of other instances, right, as harassment and cyber stalking, all of which is all too common on DCN platform. So that is broadly what I've covered within the harms that are clearly identified as legal injury. And the other categorization is harms with a less clear legal definition. So that there is no absolute lines that are drawn in terms of the law in place, whether or not they are legal injuries. So there, the example I gave of advocacy of self-harm, that doesn't necessarily, that's a very gray sort of area. There are a bunch of laws like IPC's abetment of suicide, and particularly because we see a lot of that in the background, in the context of the Facebook papers when they came out on Instagram, how it has a lot of mental health related effects. And there was subsequent reporting on how teenagers and adolescents are pushed towards a lot of self-harm. So that sort of thing within the Indian law, within the IPC, it can be covered under Section 305, which is the abetment of suicide of a child or an insane person. So such instances we've identified that there is more For example, examples that I can quote is, say, for example, something we talk about a lot, right, is disinformation. So that's very tricky because there's definitely the intent part of it. There's definitely the mens rea, as the law calls it, when it comes to disinformation, as why we can differentiate that from misinformation because of the lack of intent per se. So when that sort of intent is there, there are a bunch of laws which can be used to tackle it, but because it's so vaguely formulated, the effects of it might not be very clear. And the same goes with, say, doxing, and even something I think might be interesting to look at is revenge pornography. And I'll come back to it.
Hey, Sapni, before we sort of delve into revenge pornography, let's take a quick commercial break and we'll come back and pivot to that.
Hello. It's been another great week on the IVM Podcast Network. On The Habit Coach, Ashton meets Dr. John DeMartini. He is a world-renowned human behavior expert and founder of the DeMartini Institute. He shares 5 actionable habits to align our purpose and values. On Think Fast, Varun and Suchita discuss Disney Plus Hotstar's swelling subscription numbers and actor Dwayne "The Rock" Johnson's new alcohol brand, Teremana Tequila. On All Things Policy, the Takshashila folk take a close look at the union government banning another 54 Chinese apps. On Smarter with Sid, Siddharth explores how Shark Tank India is changing the equation of the startup economy. And on Tere Mere Raste, Keshav takes us to Bhutan's royal capital, Thimphu. Do follow us on social media. We're IVM Podcast on Twitter, Facebook, Instagram, and LinkedIn. And remember, if you're enjoying this show or any of our other shows for that matter, please do tell a friend. It really helps us. Don't forget to rate us on any of the platforms that you're listening to. And also remember, you can check us out on YouTube at www.ivmpodcast.com/YouTube. And finally, we'd like to thank our sponsors this week, SBI Life Insurance, Bank of Baroda, and HDFC Life Insurance. Thank you so much for making this possible.
Hi, welcome back to All Things Policy. We're off to a fascinating side tangent where Sapni is taking us through some incredible information. So, Sapni, do you want to continue and take us through the revenge pornography aspect of this?
Right, sure, thanks. So as I dropped off, sort of talking about how there are legal harms with less clear definition, identifying them as and the victims as having been subject to legal injuries. So revenge pornography is an excellent case study of that, where there are laws in place like the IT Act. Within the IT Act, there is punishment for violation of privacy. There is punishment for publication of obscene materials without consent, etc. And there are further, obviously, the age-old laws within IPC also prevent that. But again, to sort of implement it takes a lot of detours and, a lot of nuanced arguments to get to the point of acknowledgement within the law, saying that, yes, this is a legal injury that the victim had to go through, and because of which the victim deserves justice, which obviously translates into punishment for the perpetrator and penalties, etc., as in how they are sort of, as in how they come and fall into place. So there, I think it's interesting, and we've also discussed this in the document about this particular case called Animesh Bakshi. So this case is titled State of West Bengal versus Animesh Bakshi, where a trial court, and this is where it gets really interesting, right? So the fact that there are a bunch of laws and they can be applied, and that did not need a Supreme Court or a distinguished constitutional court to sort of bring that interpretation forth, is where we will clearly have and observe the differences that the current legal framework can make for the set of legal harms that can happen on DCNs and broadly on the internet as well. So here, this was a trial court judge in the district of Mednipur, I hope I'm pronouncing it right, in West Bengal, adjudicated a matter relating to revenge pornography, and it's probably one of the first decisions from India where the accused was convicted for non-consensual sharing of sexual images online under the provisions of the IPC and the IT Act alone. So something we often see come across as protection of women, protection of children. These are very recurring justifications when conversations about, oh, we need a new set of laws for social media platforms, or we need a new set of laws for encrypted platforms, etc. When that happens, we see this. And so broadly, again, I think this comes back to the point that I was initially talking about, how there are laws that we have, and our laws, if interpreted rightly, innovatively, they can be used to achieve the ultimate objective of justice in cases of a lot of online harms. So the broad point, hence, that I'm trying to make through this document is that we need to be aware of the scope of these laws that we currently have before we jump into more into creation of new laws, which obviously has the higher chance of sort of erring in the side of over-regulation, whether it could range from censorship to censorship and on all other kinds of limitations on the freedoms that the Constitution of India grants us, which might not be necessarily covered by the restrictions the Constitution of India allows us to place on those freedoms.
Thanks, Sapni. One thing I would like to sort of point out is that Prateek's got a good body of work and is working around stuff like this. And I'd love to get your thoughts on it, Prateek. Do you have something to add?
Hey, yeah, thanks, Rohan. So, while not related specifically to this document, right, but as Sapni was talking about the fact that hey, there are existing laws, and we should also be looking at trying to understand how they're applied. Right now, some of you may know that I also happen to write a Substack publication. I don't like to call it a newsletter, right, on India's information ecosystem. And one of the things that I've been trying to do through that in recent weeks is basically trying to understand the various ways in which FIRs etc. are used against people for content that they post on social media or as a result of content on social media.
Before we proceed, Prateek, can I just add that I am a frequent reader of the newsletter, and I think it's fascinating the kind of stuff that you do work on, and with regard to FIR tracking and so on. I really just humble plug over there for you. That's it. Yeah.
Yeah. Today, for once, I plugged it before you could do it. But anyway, so coming back to this, right? So this is essentially all building up towards trying to answer the question of, hey, should India have an anti-disinformation law, right? And this is a question that's been on my mind, ever since I started looking into the subject. But it sort of was sparked off again by the recent Parliamentary Standing Committee on Information Technologies report, which essentially advised the Ministry of Information and Broadcasting to study such laws in other countries, right? Now, so what we're trying to do basically with this is, essentially getting a sense of the ways in which the Indian state prosecutes false information or hate speech, etc. And then, are there any clear patterns that we can see once it starts building up into a sizable resource, right? Now, what we've tried to do, or what I'm trying to do rather, with this is focusing it mainly on what we defined as narrative harms in the first paper that Sapni also referenced about categorization of harms attributed to digital communication networks, and this plays largely in the field of where there is potential to control and manipulate information, where there's potential, where there's implication for trust in institutions and social cohesion in general, right? And then I guess a byproduct of that is that a lot of individual cases of harassment, blackmail, cheating, etc. will not likely make it on the tracker. That's not really that's not a comment on their relative importance. It's just a question of resources that I have as one person doing this, and the goal of the tracker, which is about should India have an anti-disinformation law, or how are we using our current laws, right? So I know, Rohan, you wanted to make a pun on this, so I do write about this as the firing line
or as I would say,
college.
it's Firse. Sorry, let's go.
yeah. So just a couple of caveats here, right? In the sense that because this is based largely on news reports and FIRs, there is potential for bias, right? So the data, the tracker itself shouldn't be considered exhaustive. I think we'd be better off considering it indicative at best, right? And of course, the fact that it relies mainly on news reports in English also plays a role there. And I just want to point out a couple of things, right? So the way I've tried to organize this in a couple of ways. One is if by the type of action that's taken. So this could be if there's an arrest or a case or an FIR or a detention of some sort, or if there are threats. I've sort of started tracking court proceedings as well. The other is by target, and this one's interesting because it's either the target can either be the post or it went viral in courts, right? And this is an interesting one because you see a lot of news reports where it seems that action has been taken only after the post went viral, and I think that's an interesting question, right? For those of us who are worried about the equal application of law, it's an interesting question of how important is the dynamic that law enforcement agencies jump in only after a certain event goes viral because of and then catches public attention because of outrage. So I pause there. I think I'll include a link to my tracker and hopefully do another update by the time this episode goes out. But yeah, I'll stop there.
Hey, so I'm conscious that we are almost out of time, and before we end, I would like to ask either of you for concluding thoughts on this matter, because I think it's a developing space and something to keep an eye out for. So, Prateek, Sapni, you want to go ahead and take that?
Yeah, so I'll just reiterate, right? I think, and Sapni made this point, and that's the whole point of the document as well, is that, look, it's normally easy for us to jump into trying to create a new regulation. And while in some cases that's very warranted, it's important before we jump into that to make sense of the existing landscape, right? And which is essentially the question that we're trying to ask here, right? Trying to get people to pause and think and ask that question before creating new regulation, which sometimes, it also creates this thing of, hey, we're doing something about it, right? And so we're trying to address that situation essentially.
And I think I would just have probably an ask to our regular listeners. So what the document obviously will be linked into the show notes, but I've tried to make it as exhaustive as I possibly could with very generous help from a lot of people who contributed to it. But if there are instances which listeners do think that I've missed, should please reach out to us at Takshashila and we'll be glad to actually update it and make it more exhaustive.
Right, thanks. I will just add that Sapni, of course, is a fantastic resource. So if you don't, please follow her on Twitter, and that might be super useful for your information diet. So thanks, Prateek. Thanks, Sapni, for joining in. And we'll see you in the next episode of All Things Policy.
If you liked our show, don't forget to check out other interesting podcasts on the IVM network. You can tune into them on the IVM Podcast app, ivmpodcast.com, or wherever you listen to your podcasts. You can also follow IVM on social media. The handle is @IVM Podcasts on Twitter, Facebook, and Instagram. And hey, if you'd like to dive into Takshashila's research on technology, strategy, and economic affairs, check us out at our Twitter handle @TakshashilaINST or our website takshashila.org.in.
जिस तरीके से हमारे माँ बाप ने अपने करियर की सीढ़ियाँ चढ़ी थी, वैसे आज के जमाने में तो पॉसिबल है ही नहीं गुरु, क्योंकि हमारा जमाना इतना कॉम्प्लिकेटेड है। आज क्या नहीं है, कंपटीशन है, सोशल मीडिया है, इतना इंफॉर्मेशन ओवरलोड है कि करियर का टेंशन ज्यादा होता है, उस पर काम कम। टेंशन लेने से कोई फायदा तो है नहीं। क्या करते हैं, ठंडे दिमाग से सुनते हैं प्रोबेशन से प्रमोशन तक पॉडकास्ट को हर सोमवार, जहाँ पे सिर्फ प्रैक्टिकल बातें होती हैं आपके करियर की। और कौन करता है वो? मैं आपका होस्ट अभिनव त्रिवेदी। ये पॉडकास्ट आप सुन सकते हैं IVM पॉडकास्ट की वेबसाइट, ऐप या फिर किसी भी अन्य पॉडकास्ट स्ट्रीमिंग प्लेटफॉर्म पर।
You're the people pleaser, right? Oh, yes. Or then desperately seeking the one? Oh, wait, you're the one who doesn't think they're ever good enough. Oh. So much drama. And for what? Is it doing you any good? Listen to me. I'm Chetna, your favorite positive action coach. Yes, I'm the one who has been dropping all those truth bombs on every episode. Oh, no. And it's time you learn to say no to drama. That's also what my podcast is called. And a new episode is out every Monday and Wednesday on the IVM Podcast app, website, as well as all major podcasting platforms.